My name is Dan Hetzel. I'm an entertainment attorney here in Chicago, and tonight we're going to talk about copyright law. So the first question is, what is a copyright? Copyright is the legal method you use to protect creative ideas or works. For most artists, the obvious thing they need to protect are the songs they make. This is different from a trademark. A trademark you use to protect a name or an identifying brand, like a logo or the name of something. Copyright, that's what you need to use to protect your music. Now, everyone always asks, does my copyright exist before I actually get my copyright from the government? The answer to that question is, if you have created a song, even though you haven't gone and got the copyright, you still own the copyright. So no one technically can steal that song from you. So if you've just created a song on Pro Tools in your basement and you haven't sent it off anywhere to get copyrighted, don't worry, you actually automatically own that copyright. But it's very important to register your copyrights. The copyright registration process is simple. It involves going to the federal government website, www.copyright.gov, and simply filling out one or two forms, including your information and address and the name of the song, and then you upload the song on the website. It's very easy, and it only costs $35 to do. It costs $35 to copyright a single song, but you can actually copyright a collection of songs for the same $35. So if you get a chance, artists out there, you have some songs, you haven't copyrighted them yet, put all these songs on a list, and you can literally upload those 20 tracks to the copyright site. As soon as you upload it, your copyright is official. So now that we've covered how to get a copyright, let's talk a little bit more about the details of copyright law. Now, the first thing to understand about copyright law is when you're copyrighting a song, there are two pieces to every song. I like to think of it as the general version of a song and the specific version of the song. The general version is called the musical composition. The specific version is called the sound recording. Now, when you go to register stuff on the federal government website, if you copyright something, you are automatically copyrighting both pieces of the copyright. But as an artist, you need to be very aware that both of those pieces exist. So I'm going to give you an example. When you sign with a label, the label typically wants to own some of your copyrights. If you don't know that and the label insists on copyright ownership, you'll just assign the song over to them and the label will own both pieces of the contract. But if you're an experienced artist, you can often convince the label just to take ownership of the sound recording while you hold on to the copyrights for the musical composition. Now, think about the advantage to that as an artist. True, the company owns the sound recording, which is the specific engineered and mastered version of the song, but the artist still owns the musical composition. That means since the artist owns the general version of the song, he can re-record the song and make multiple sound recordings, and in theory, he could then sign with other labels if the situation goes bad with his label. So that's one of the building blocks of copyright law. And again, to summarize, it's the distinction between the general version of a song and the specific version of a song. Now, the second step to understanding copyright law is understanding the basic rights that come with copyright. There are 6 rights that come with a copyright. There's the right to distribute the song. There's the right to reproduce and re-record the song. There's the right to publicly display the song. There's the right to play the song on the internet. And there's also the right to publicly perform the song. Now, those 6 rights are so general that they almost go over your head, but think about it the other way around. If you give up your copyrights, you don't own those rights. So if you give your copyrights to a record label, then they get the rights to reproduce, perform, and do these other things with your song. You literally can't do anything with your music without the record label's permission. And don't get me wrong, I'm not saying never give a label your copyrights, but be very aware of what you're giving up, because once you've lost the copyrights to a song, you effectively have no ownership in it. Now, another important point of copyright law to understand are the rules about who owns what when music is created. If you're a one-man act and you make beats and you sing over them, then you obviously own everything. But think about if your friend makes the beat and you write the lyrics. So how does that song get divided? Or think about if one friend came up with the hook, the other two people spit the verses, and a whole different person had made the beat. And then all that got bounced down onto a single MP3 and marketed as a song. Who owns the copyright? Who owns what? Well, the law makes it very easy to make that determination. The default rule under the law is if you've created any part to a song, you automatically become a copyright owner. So even if you just wrote half of the hook of a song and one other person did everything else on the song, you guys would both be copyright holders. Now that means you both have those 6 rights I just talked about, and you don't need the other person's approval to exercise those rights. So the person that wrote the hook could go market the song and do whatever he wanted to, and the person that did everything else could also, if he had a falling out with this guy, take the song to a whole separate label and try to market it. But you obviously don't want that. So it's very important as an artist to make sure that as few people as possible have copyright ownership. Now, I'm not saying try to jerk people out of their rightful positions in a song, but what often happens is people that made very minor contributions but were there will later try to claim ownership of the song. And as memories fade, people start to remember more and more of supposedly what they did, especially after a song has started to make a lot of money. So you need to be very clear about who made creative contributions to every song. And the way to do that, professional artists use split sheets. When they go in the studio, they bring a sheet. And if you guys contact me, I can send you one of these sheets over the internet. These split sheets just say, okay, who contributed what, who's their name, and then they also contain information about publishing and royalty payments, which we'll talk about in the next session. So these split sheets, an example would say, okay, Biggie Smalls wrote the hook in the second verse. Some DJ made the beat. And then they would say some other artist wrote 50% of the first verse and 30% of the last verse. You see how it can get detailed. But once you've done these split sheets, there's really no issue. And that also prevents, if there was someone there that later tried to claim, oh, I came up with the ad lib or something, then you could cut them out. But by definition, even if you do an ad lib on the song, that could technically make you a copyright owner. That's why Puffy used to say, take that, and all these stupid ad libs in the back, because he would cut himself in to the copyright ownership that way. So the best way to lock in your rights to copyrights are to keep unnecessary people out. The first way you can do that is with a split sheet. The second way you can do that is with a short contract called a work for hire. A work for hire is a document that you want someone to sign that has agreed to help with the song, but they're not necessarily like really that big a part of the creative process. An example would be a backup singer or someone you hired to play the drums if you'd already written the music for the drums. A work for hire basically says, okay, I'm accepting this job to create this song for so-and-so, and I'm not going to claim any copyright ownership. Typically, they get paid something, and the idea is you're paying them a fee to do this, and they're not claiming to be part of the creative process or claiming copyright ownership. Now, you can also use a work for hire really in any context, and you can use a work for hire even if someone did create part of the song. You can get them to sign a work for hire and say, look, I just did this for you because you paid me. Now, that might sound a little shady, but think about the most famous example of that there is. Disney, the biggest entertainment company in the world, they make you sign a work for hire anytime they hire you on to create a song. So Disney says, look, for Little Mermaid, I'm going to hire you, producer, to make a song that's lighthearted and teens will like, whatever. Before that artist even puts pen to paper, Disney has him sign a work for hire that says, look, as a creator of the song, I would naturally be entitled to the copyrights, but I'm going to give them over to you. So to summarize, that's a work for hire, and artists, even though you're not famous yet, this can be very useful. If you've collaborated with people on songs, definitely create a split sheet and definitely use a work for hire contract. Another example would be if you were hiring a producer to produce a song for you. Now, if he's just engineering it, that's different. But if he's going to kind of mix up the beat a little bit, play with it, say he has some examples for how to rephrase the hook, etc., that would naturally entitle him to be part copyright owner. But if you use a work for hire, that will make it clear, okay, even though I'm producing this, that's all I'm doing. You paid me $200 or $2,000 to produce the song, and that's all I'm getting out of this. So that's some real basic building blocks of copyright law. Now, the reason copyright ownership matters in terms of the bottom line dollars and cents is you are entitled to certain royalties under the law by being a copyright holder. So if you own the copyrights to a song, there are two main things you get. First of all, you get publishing royalties, which means you get 9.1 cents every time your song plays on the radio or on internet radio. And in limited circumstances, you can also get performance royalties if your song plays on television. So just think about how much the guy that wrote that Simpsons intro jingle, he gets paid 9 cents every time that airs on a network. That amounts to millions of dollars literally every month. So to rephrase, the first main economic benefit of copyright ownership is that you get 9.1 cents per publishing royalty every time your song plays on the radio. Now, the second royalty you get by virtue of copyright ownership is called a mechanical royalty. That is what you get every time one of your songs is pressed on a CD or DVD. So if you wrote 10 songs and these 10 songs are used on a DVD for background music or whatever, you get 9.1 cents per song per DVD. So 90 cents, say a million DVDs were sold, that's a nice piece of change right there. But a lot of artists don't realize this, so they don't take the steps they need to get this money. So an example is a lot of Chicago hip hop artists don't realize that if their songs hit the radio, they can get these performance royalties. Now, if you have a big hit on the radio, you're not going to see any of this money automatically. So what do you need to do to see this money? It's very simple. You need to sign up with ASCAP or BMI. They are the agencies that collect this money. Every time your song plays on the radio and a 9 cents gets generated, if you've registered with ASCAP or BMI, they keep that money in an account for you. and they pay it out every couple months. And they do that for as long as the song is generating money. So if you're a hit producer, you can be getting royalty money 20 years down the road. To get mechanical royalties, there's a similar company you need to register with. They're called the Harry Fox Agency. They keep track of how many copies of your CD or DVD have been pressed. And they make sure that you get that same 9.1 cent mechanical royalty for the appropriate number of physical copies. Now, this is different from artist royalties that you typically think about. Okay, an artist gets 20 points on their album, or an artist gets, so what does that mean? That means an artist gets 20% from the record label of the retail price of the CD in Best Buy or Walmart. But keep in mind, that's different from the royalties we're talking about. Those record label royalties come from the record label, and they're negotiated with the artist. If you're just the artist that performs the song, like Beyonce and Single Ladies, Dream wrote the song. Dream was the copyright holder of that song. So he does not get artist royalties off the album, but he does get these publishing and mechanical royalties. Anyways, there's a lot more to say about this. If you need advice or legal help, feel free to give me a call, 773-354-2331. I also teach a class at Music Industry Workshop, which is a 9-month course on this entire topic. Again, Music Industry Workshop, you can look them up on the internet. They're right here on Chicago on Claiborne, Fullerton, and Ashland. Okay, we're still good. There are two ways to join ASCAP and BMI. My name is Dan Hetzel. I'm an entertainment attorney in Chicago. Phone number 773-354-2331. Tonight we're going to do part 2 of a 2-part discussion of music business. In the first portion I discussed copyright law, and now I'm going to address some very important miscellaneous topics. The first topic I'm going to talk about is something called a 360 deal. To understand major label deals these days, and really any sort of indie or other sort of record deal, you need to understand the 360 deal. The 360 deal essentially means that when an artist signs with a label, the label is going to get a percentage of every area of income that artist brings into the label. Now, traditionally, an artist would sign to a label, and the only money the label would get would be the money they made off selling CDs. So the artist would keep their 15 points on a CD, and the label would get 85% of the money from selling CDs. And that meant that the artist was free to earn other money however he wanted to. So if the artist went on tour, typically, it's hard to imagine these days, but typically the record label wouldn't get paid off that. Also, if the artist sold merchandise, he could keep all that money. And that was traditionally a way where up-and-coming artists made a lot of money on the side. Also, any endorsement deals the artist made, he could keep that money. The label didn't get a cut of it. Well, all that changed a couple years ago. And what precipitated the change was that Live Nation joined with Ticketmaster, and they created the largest entertainment conglomerate in the U.S. field. Now, what that gave them the idea, okay, we have a booking agency that's going to be able to book all these shows. Let's sign an artist and sell their albums, but let's also get money from the shows. And hey, while we're at it, let's get money from everything the artist does. Now, that's when Jay-Z had his $200 million deal, Madonna had her $200 million deal, and it seemed great. But when you think about it, a 360 deal is really giving up a lot of rights for the artist. Now, the reason 360 deals have become prevalent was, number one, as soon as labels saw the Live Nation merger, immediately every label said, oh, I'm going to ask for a 360 deal. And artists, being kind of slow sometimes, were happy to just see the money up front and went with these 360 deals. But if you're going to do a 360 deal with a label, you really need to understand how that label is going to help you earn money in every single aspect of your career. Because if your record label is not going to help you tour or book venues, then they shouldn't get a cut of that money. But the reason 360 deals are prevalent is a little more profound. Record labels have really stopped effectively selling huge numbers of CDs, so they are now more dependent on other areas of income from artists. For a while it was touring, but this year touring revenues are way down. Now it's become commercial endorsements. The best example of that, Britney Spears made $1 billion off her perfume. And this was at a time when she was largely regarded as a musical failure. She made 100 times more money off that perfume deal than she did actually selling physical CDs. Now, that makes a big difference for her label. Under a traditional label deal, the label would not have got a piece of any of that money. Under a 360 deal, they certainly would have. Now, the other reason artists need to be very careful about 360 deals is when a company signs an artist, sometimes they give you an advance, sometimes they don't. But either way, they put a lot of time and money into you. And artists don't realize this, but you have to pay them back. This is called a recoupable. When a label gives you a $50,000 advance and drops another $100,000 to make your album, first of all, you have to pay taxes on the advance. So you'll only see $35,000 of that 50 grand, but you have to pay back all that money to the label before you see a dime. And the way you pay that money back is typically from the royalties you earn on selling your album. Now, under a 360 deal, they can tap all that money to make you pay back. And as you can imagine, labels inflate these recoupable amounts. They'll say, oh, well, I picked up the phone and called Funkmaster Flex, so I'm going to charge him 15 grand for that, because that's really what that was worth. And you have to pay that 15 grand back as a lawyer. Same thing when they buy you a huge chain or expensive jewelry or fly you around on chartered jets. You're paying for that money back out of the money you've earned. And under a traditional record deal, they could only tax your artist royalties. But under these 360 deals, they can tax all the money you make to pay them back. So anyways, we've been talking about 360 deals. If you're an artist out here and you get offered a deal today, it's going to be a 360 deal. That doesn't mean you walk away from the table. But if you understand copyright law, you can negotiate that deal. And hopefully you can knock out some of the areas they want money for. And that money could very well be the money you live on for the next year or two, even after you've released a major album. Because during that process, you're still paying the label back. Now, let's switch gears and talk about kind of do-it-yourself companies. These days, people don't want to sign with majors. Everyone wants to have their own label or their own company. And that's actually very smart. But let's think about the most practical reason that your everyday artist would want a company. The main reason for a company is that it protects you from personal liability. Now, if you're conducting business and you get sued, if you're conducting business as an individual, you could be held personally liable. If you're conducting business as a company, you are protected, and they can only reach the company assets. They cannot sue you personally. So if you enter into a production deal as a producer, but as your company, not Dan Hetzel, the producer, Then if you get sued for copyright infringement, they can't sue you and they can't take your car and they can't take your house. All they can take is the assets of your company. So to everyone out here watching this, if you're trying to set up a record label, you need to set up a company. And in Illinois and any state, there are two basic ways to do it. You can form an LLC or you can form some sort of corporation. It's very simple. You go to the Secretary of State, you fill out some paperwork, and they charge you $500 to set it up. Now, to govern an LLC or a corporation, you need something called an operating agreement. And you need an attorney for that. You need to meet with the attorney and figure out, okay, what are going to be the rules of this operating agreement? But it's basically just whatever you say it is. It's how you and your partners run the business. But anyone can file an LLC or a corporation. Go down to the Secretary of State and just do it. So that's how to form a corporation, and I've explained why it's important to form a corporation. Again, the reason is to protect yourself from getting sued in the course of conducting business. Now, people go cheap on this process and set something up called a DBA. That's short for doing business as. You can go to the Secretary of State and pay $20 to get a doing business as license. That will allow you to function as a company, but it does not protect you from personal liability. So if you don't have a lot of money, either set up a DBA or don't do anything for now, but when you start to make money and when you run the risk of being sued, you absolutely need to set up some sort of corporation. This goes for record label owners, producers, or even artists. And then once you built your label up or your entity, you can try to get production deals or imprints or joint ventures with labels above you. So setting up a company is a good way to leverage yourself up to the next level of the game too. I'm going to talk about one more topic really quickly, and that's digital distribution. In the past, artists basically had to sign with a record label because record labels had the relationships with distributors that they could distribute a mass amount of physical CDs. These days, though, people are buying CDs less and less. By the way, Justin Bieber had 1 billion downloads last year, and you can assume most of that was from kids. That means, as I talked about in my earlier lecture, he gets royalties on every one of those downloads. So that's just like mind-blowing. But anyways, you can do a digital distribution deal by yourself over the internet instead of signing with a label. And that will make your songs available on iTunes, on every single medium there is for getting your music out there digitally. And you can do these cheaply. There are a variety of companies that offer digital distribution deals. TuneCore is the name of one of them. You can register your songs for like a 99-cent fee, and they'll be available on all these different websites. Now, you can also put your music up on different free download sites. That's a way to kind of promote it and get it out there. But in terms of digital distribution, that will make your song available for purchase. So I would really encourage all you artists and all you kind of indie record label owners out there, go ahead and do that. That's easy to do. There's no reason not to. But you need your stuff copyrighted if you're putting it out on the internet. Now, if you're going to do that, you need to register with a company called Sound Exchange. Just like ASCAP and BMI collect your radio royalties, Sound Exchange collects your internet royalties. So anytime your song gets played on internet radio, you get a 9-cent performance royalty. This does not cover downloads. That's not considered a quote-unquote performance. So when someone downloads your song, or even when they play it on YouTube, you don't get a performance royalty for that. But if you're on internet radio, any sort of internet radio, you get 9.1 cents every time your song plays, and you need to be registered with Sound Exchange to get that. Again, Sound Exchange is the equivalent for the internet as what ASCAP and BMI is for the radio.